Okay, so I'm going to talk a bit about independent contractors and how they are different than employees and things that you might want to be aware of before you go and hire independent contractors. This is probably something that a lot of employers, or many of you in this webinar, are doing these days, is hiring independent contractors rather than employees. And there's some advantages to it, which we'll talk about, but it is important to know that if you're wrong, if you call somebody an independent contractor and they're really an employee, there are big consequences. There's consequences from CRA, from WSIB, there's consequences from employment standards, there's consequences in courts. So I think the reasons why employers like to hire independent contractors are pretty obvious and straightforward. Employees need to withhold and remit federal and provincial taxes, CPV contributions, EI contributions, and make contributions on the employee's behalf. In general, they have to remit WSIB premiums to the Workplace Safety and Insurance Board. They have to comply with the Employment Standards Act, ensure that minimum employment standards are met. And JP talked about what some of those are. Whereas if you have a contractor, you really don't need to worry about any of that. What you need to worry about is that you comply with the terms of the contract. In many cases, employees like to be considered contractors as well because there's some tax advantages for them. But the relevant agencies are cracking down, and you might have seen some news about this in recent months where. In fact, CRA has taken a policy position, it's right on their website, that they are conducting more payroll audits for this specific purpose. So this is a big deal now for many employers. But in fact, just a couple of months ago, there were some articles in the Ottawa Citizen about some technology workers, some IT workers that were providing services to the government, to the federal government, through their own corporations. And CRA has determined that these were not actually independent contractors, but were employees, or ought to have been considered employees. Now, the consequences in those cases are with respect to the employees themselves, and they're losing those tax advantages. And they haven't cracked down on the employer, but of course, in that case, the employer is public service. So, if for those of you who are not the public service, you can expect some pushback by CRA, WSIB, and ESA. So, what are the elements that these agencies will look at? Well, each of these agencies will do their own analysis and conduct their own tests, and the tests for each are worded slightly different. But at the end of the day, the elements are the same. And the elements are control, ownership of tools, chance of profit and a risk of loss, and integration. And I'll talk about each of these briefly. By control, what these agencies want to look at are things like who controls the hour, who sets the hours of work, who sets break times, who sets lunch periods, who provides a list of responsibilities or tasks to be done during a particular day or week, who tells the individual how the tasks should be completed, where the tasks should be completed, etc. So those are the elements of control. Ownership of tools is really just what it sounds like, but of course tools can include everything from equipment that is necessary to perform the work, to computers, to software, and things like that. So does the employer or the company provide licenses for use of Microsoft suite of software, for example, or is that the employee's responsibility? So that's another element. Chance of profit and risk of loss really refers to having the hallmarks of a business. So for an independent contractor, what the government wants to see, what the agencies want to see, is that the individual providing the services is running their own business. So is there a chance of profit, or is it simply, and risk of loss, have they made an investment of any kind in order to do this work, or are they simply performing a task in exchange for a fixed sum of money? And finally, integration into the workplace is important and something that's often overlooked by employers. And by that I refer to things like, does the individual participate in the firm's Christmas party, for example? Do they come to the staff room to have a birthday cake for an employee? Sounds kind of ridiculous, but These are some of the, this is one of the elements of CRA, for example, and all of them we'll look at to see if they're really a part of this business, a part of this workplace, or are they independent of the workplace. And one of the things that I see very often is clients come to me and say, but they show me the employment contract or the independent contractor contract and say, well, look, it says right in there that the employee or the individual agrees that they are not an employee, that they are an independent contractor, and the agencies just don't care. That is irrelevant to the analysis. What they'll look at is what is happening in de facto, what is happening on the ground, rather than looking at the terms and conditions of an employment contract. Now, what are the consequences of getting this wrong? With CRA, you'll end up, the employer will have to pay the CPP and EI contributions that were not withheld, plus their own contributions. And they're, of course, CRA, so there's interest and penalties that would accrue on those amounts. In addition, for an independent contractor, the employer would not have withheld income taxes. And CRA will at first go after the employee for those income taxes, but if they can't collect, they will come after the employer for those amounts. And there are penalties for failure to withhold as a fixed percentage of the amount that ought to have been withheld. So it can get pretty steep. But what you can do in advance is ask CRA for an advance ruling. You make a submission to CRA. They have a form for this on their website, and you explain the terms and conditions of the contract, and you answer certain questions, and then they'll tell you, they'll provide you with a binding ruling as to whether or not this individual is an independent contractor or not. The best way to protect yourself from a CRA payroll audit is to only retain incorporated entities if you want to go the independent contractor route. That won't provide you with complete protection from CRA, but it will go a long way, because if there is an incorporated entity, then CRA has a way to ensure that they're getting their money. First of all, the corporation has to pay corporate taxes, but even if the CRA decides that it's really not an independent contractor, that really is an employee, what they'll do is decide that the corporation is a personal services corporation and remove all of those corporate tax benefits that the employee otherwise had and get the money on that side. Now, the employee will end up paying even more than they would have had they been a regular employee. And so while that's not really a risk to the employer, it's the employee that's going to be on the hook, it does create problems in the employment relationship, because I've seen employees or independent contractors that get dinged in this way and come back to the employer and say, look, you enticed me, you pushed me to create this situation and create this entity, so I want you to pay for my penalties. I want you to pay the extra taxes. So there is some risk there, and it's something to keep in mind before you go this way. But that is the better way to protect yourself from CRA. I can tell you that won't protect you from WSIB. WSIB doesn't care if your independent contractor is an incorporated entity or an individual. If in their analysis this person ought to have been an employee, for WSIB purposes it's defined as worker, and that's how they get away from this corporation versus employee. So if they're a worker as defined by the Act, you need to pay premiums to WSIB. And if you don't pay those premiums, obviously the employer will be on the hook for unpaid premiums, but there's also interest and fines. There's also the potential for prosecution under the Provincial Offences Act. That's unusual, but it is done on occasion. So there's some severe risk by being wrong with respect to WSIB. Now, WSIB will allow you to submit what's called the Independent Operator Questionnaire. They have specific questionnaires for different industries, and you'll find that all on their website. You can always call us, and we've got quick access to those. And then they'll make a determination as to whether or not the person is an independent contractor or not. Subcontractors can create problems for employers, and that's if you retain an independent contractor, even if they are in fact an independent contractor, and that contractor retains subcontractors of their own, you need to make sure that the independent contractor that you've retained is paying WSIB premiums with respect to their subcontractors. Because if not, and if they were required to do so, then WSIB will come right up the chain to you And even though it's the independent contractor that was retaining the subcontractors, if they can't get their premiums from that independent contractor, they'll get them from you, the employer. And the way to deal with this risk is to ask all subcontractors for a clearance certificate. Now, this is something that the independent contractor can get very easily. They can get it online, and there's an electronic version. They get it instantly, or within 24 hours, I think. And it just shows that the independent contractor is registered with WSIB, and they're up to date with whatever payments they need to pay. And that will fully protect you from that subcontractor problem. ESA, I didn't get into ESA issues here, but the test is the same. Of course, if ESA determines that the person was an employee rather than a subcontractor, then you just need to make sure that you're providing them with the minimum entitlements in the Employment Standards Act. But there is one element that twists this all on its head, and that's the this issue of dependent contractors. Now, this is something that's been mentioned by the courts over the last decade or so, but was never really confirmed as a real category of relationship or contract between an employer and a worker. But in the last, I think, year and a half or so, the Ontario Court of Appeal has actually formally recognized this kind of relationship. Now, this doesn't have any impact on CRA's analysis or WSIB or even ESA. But what the Ontario Court of Appeal has said is that if there's a claim for wrongful dismissal and the employer defends itself by saying, well, no, this person is not an employee, this person is a contractor, and therefore I'm not required to do anything other than what's in the contract, then the court will do a two-pronged analysis. The first thing the court will do is decide whether the individual is an employee or a contractor. If they're an employee, that ends the analysis, and the court will make whatever order is deemed necessary for an employee. But if they're considered to be a contractor, then the court will analyze whether the person is an independent contractor or a dependent contractor. And the difference between the two is really right in the name. Is the individual dependent on the employer, on the company, for their livelihood? And the main hallmark of this is exclusivity. Does the individual exclusively, or almost exclusively, work for the employer, provide services to the employer? And if so, they're likely to be considered a dependent contractor because their livelihood is dependent on that, on the employer. And the impact of that is that the employer will now be responsible to provide notice of termination of the contract or pay in lieu of notice, just like it would for an employee. They won't have the other consequences that come along with it. They still don't have to withhold income taxes or CPP or EI or any of those things. But the court has said that it's unfair to allow somebody to become dependent on one corporation, one employer for their livelihood, and then just be dumped in this way. So that's where dependent contractor comes from. And it really just makes it that much more difficult to create independent contractor relationships in your businesses.